Hello ladies and gentlemen, this is Annalise Garrison coming to you again. I know I haven't put up a video in quite a while and I feel that I need to. Because legal questions are coming up on the NCLEX and people don't understand what the legal terms mean. So in this presentation we're going to do legal items you should know for the NCLEX. Now, when I first started this presentation, I was going to do terminology, institutions, and patients' rights, whether they were mentally ill or not, because the legal spills into both parts of the society, the mentally ill and the people that are just sick, right? But this turned out to be 17 slides alone, so for this slide for this presentation I'm just going to do terminology, okay? So in this presentation we're going to learn a lot about the different kinds of legal terms that you may or may not know. We're going to learn about intentional tort. We're going to learn about assault versus battery. We're going to learn about slander. And we're going to learn about libel. Continuing on, we're going to learn about what exactly is malpractice. That word gets thrown out a lot, but people don't really understand what it means. We're going to learn about false imprisonment. Again, another word that gets thrown around a lot, but people don't really know what it means. Negligence. This is probably one you have not heard of. Writ of Habeas Corpus. So these are the terminologies we're going to learn about in this particular presentation. Okay, so everybody get your pen and paper and let's start from the top. What is an intentional tort? A tort simply means a wrongdoing, right? An intentional tort is a category of torts that describes a civil wrong resulting from an intentional act on the part of the tortfeasor or the alleged wrongdoer. Okay? So, in other words, you did something civilly wrong and you intentionally did it. This would make it a This would make it an intentional tort. It's a civil wrong that you did on purpose. Right? Good job. Let's go on to the next slide. Now, assault versus battery causes quite a lot of confusion. Alright? When you take your NCLEX, remember that there are three types of assault: physical assault, emotional assault, and sexual assault. Now, the NCLEX mostly deals with physical assault, but that's not to say they won't ask about emotional assault or sexual assault. All of these can be assault, but not battery, and vice versa. Now that's very confusing. How could something be assault but not battery, and how could something be battery but not assault? Well, I will explain it to you. Okay, this is an example of assault. 83-year-old Garrison has been following you around for the better part of 3 hours. You are trying to work, telling you that she used to be an RN, impeding you from doing your duties. Finally, you turn to her and say, "Annalise, if you don't sit down, I'm going to put a restraint on you." This is assault. Why is this assault? Because you certainly had the apprehension they were in the hospital or they were in the nursing home, and you certainly had the means to put a restraint on me. So you made the threat, and I am apprehended. I'm in a facility in which you can do it. Even if you did not do it, you could still be in trouble for emotional assault. Once you do the act, it becomes battery or physical assault. Okay? So, very good. Keep taking notes. You're doing great. So, I mentioned earlier in the slide that assault can constitute battery and battery can constitute assault. But that didn't really make much sense. What is the difference between assault and battery? Okay. Well, with assault, remember you had to have the person confined and you did not have to make physical contact, just the threat of whatever you told them you were going to do to them, right? So then what is battery? Battery is the tort of intentionally and voluntarily bringing about an unconsented, harmful, or offensive contact with a person or to something closely related to them, like a hat or a purse or their family dog, right? Unlike assault, battery involves actual contact. And this is the difference between assault and battery. An example of battery would be if you got an operation and you got your left breast removed without your consent. Okay, it was unconsented, plus the primary care provider actually touched you. He made contact with you. You understand? That's the difference between assault and battery. Very good. Let's keep continuing. Okay, the next thing I'm going to talk about here is slander versus libel. Okay? Now, a lot of people misunderstand this. And during my tutoring sessions, sometimes they argue about it, which I allow them to argue. If they don't want to listen, that is fine. All right? They'll just get it wrong on the NCLEX, right? But here we go. Slander versus libel. What is slander? Slander is making false statements about an individual, whether in writing or the spoken word. Now, the misunderstanding comes about where people think that slander is writing and libel is the spoken word. No, that's not the way it works. Slander is making false statements about an individual, whether in writing or the spoken word, also known as defamation of character. Slander is, right? You know, don't give Annalise that job because she's blah, 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 blah. And then I don't get the job because of what you told my potential job, so I take you to court. Now, if I win the case, you might be liable to pay me whatever the judge says that my damage was worth. So this libel has two parts: reasonable by law or responsible by law or legally answerable, right? That would be me winning my case, and you would have to pay me whatever the judge um, orders. Or libel could mean something else, and I don't want you to mix this up. Likely to do or to be something. Let me use that in a sentence. In other words, if Annalise Garrison stands up from that wheelchair at this point, she's liable to fall. This is not the libel that the NCLEX is talking about. The NCLEX is talking about responsible by law or legally answerable to pay me my dues because you slandered me by making false statements or of me, whether it was in writing or the spoken word. Okay? So this gets a little confusing. If you need to, you can just rewind. Thank you, ladies and gentlemen. I hope I made that clear, and let's continue. Which brings us to our next terminology, and it is malpractice. Malpractice gets confused with negligence because it's almost the same, but in the law of torts, now what's a tort? A civil wrong. So, in the law of civil wrongs, malpractice is an instance of negligence or incompetence on the part of the professional. Now, I'll give you an example that is not considered malpractice, but many people believe that it is. And it is a nurse practicing without a license. A nurse practicing without a license cannot be sued for malpractice because she never had a license to practice nursing safely in that state, right? But he or she is impersonating a nurse. So for impersonating a nurse, of course you're going to get, some civil charges brought against you and you're going to go to prison, because anything that you need a license for, you can't impersonate a lawyer, you can't impersonate a judge, which used to be a lawyer. You can't impersonate a hairdresser, they need a license, right? You can't impersonate a police officer, they have to go to special training. You see what I'm saying? So if you practice without a license, then you are impersonating a nurse. You're saying you are something when you are not. However, the hospital that hired the nurse that didn't have a license can be sued for malpractice because they were approved by the state to practice out nursing care safely, and having a nurse working for them without a license is considered unsafe care. So that's the difference between malpractice and impersonating. All right? Great job, guys. Let's keep going. Here's another topic that brings up a lot of controversy: false imprisonment. The reason it brings up a lot of controversy, and I'm going to talk about this in the next slide, is because what you may or may not know is there's different types of institutions, okay? And they can stay there for over 6 months. They can stay there for years and years and years. I'm just going to mention them right now, what they are. We have the 3-day stay at the hospital for the suicidal attempt, The cops come to the scene, they take them to the ER, and then the crisis team talks to them, right? That's not necessarily false imprisonment because we're going to let them go in 3 days, okay? Unless we have a bigger problem with them, then they're going to stay longer. But usually that's no more than 5 days up to a week, okay? But then you have the regular institution, the state-run institution for people like Annalise, who just went bonkers one day and lost her mind, okay? And then we have the criminally run institution for people that plead temporary insanity. They don't go directly to jail. They'll go to the criminal institution. Now, can the temporarily insane criminal go in with Annalise, the regular citizen who just lost her mind one day? No, absolutely not. And then we have all these soldiers that are going to be coming back from Iraq, right? Well, we have VA institutions, Veteran Administration institutions. They get special treatment. They don't go in with Annalise. And of course, they're not criminals, so they don't go in with Charlie Manson. Okay? And then we have the developmentally challenged. These are people that are 50 years old and have the mind of a 5-year-old. They could stay there for a long, long time. But do we keep them in those institutions? No, what we try to do is every 6 months we have a multidisciplinary team meeting, right? Can Annalise return to civil life as she knew it, right? Can the prisoner who pled temporary insane, can he return to the regular jail population, right? Can the veteran who went to the VA hospital, can he go to a halfway house and learn people skills or whatever he needs to learn so that he can make his way into society, right? Can the developmentally challenged 50-year-old who acts like a 5-year-old,
Can they live in a regular group home under supervised uh, care? So see, there's 5 different types of institutions, and we'll get into that. So, and I'm going to get into that even more because it becomes important. So, in order for you to be falsely imprisoned, a false imprisonment claim must prove willful detention on the part of the person keeping you there without consent and without the authority of the law. If a person can prove all 3 of these things, they have the right to file a writ of habeas corpus. Now again, let's go over what a writ of habeas corpus is. Okay, I mentioned a little bit about it before, but I'm going to mention it again because the truth of the matter is, in every psych ward, every psych unit, we have writs of habeas corpus in the filing cabinet. It is the person's right to have a writ of habeas corpus if they believe they've been wrongly false imprisoned. However, we don't have to give it to them, nor do we need to let them know it's there. Because if everybody knew that it was there, everybody would be wanting one. Okay? So let me explain again what it is. A writ of habeas corpus is a recourse in law whereby a person can report or put in writing a unlawful detention. The reason we don't give them this piece of paper when they are first admitted is because usually people are upset. They don't want to be there. So they're going to automatically think that they're being unlawfully detained when they're not, okay? So, uh, so a writ of habeas corpus is a recourse in law whereby a person can report or put in writing an unlawful detention or imprisonment before a court, usually through an official. It's not really a full-blown court, it's a hearing, okay? However, it does have limitations. It is a guarantee against any detention that is forbidden by law, but it does not necessarily protect the person's rights, such as the entitlement to a fair trial. It's only a temporary remedy to the problem directly at hand. Now, if you have to go to trial for anything you did while you were, let's say, under the influence, okay, then that will have to be taken up with a lawyer. This writ of habeas corpus is only a remedy. It only says, no, you're holding the person against their will. They did their 3-day stay. They're not a danger to society, and they need to get out and get a lawyer and have their fair trial. But it doesn't give you the right to have a fair trial. It's only a remedy for you to get undetained. It only is a temporary solution. Okay? Okay, someone just gave me this question and asked me to explain malpractice versus negligence, and I could see where it becomes confusing. Okay, and I'm sure that the NCLEX probably talks a lot about it if they get into legal stuff, and you probably had it in school and didn't understand it either. But, okay, so in law, negligence is failure to use reasonable care resulting in damage or injury to another. Okay, in the law of torts, malpractice is an instance of neglect, negligence, or incompetence on the part of a professional. So what is the difference between the two? Okay, well, negligence is the failure to use reasonable care. Okay, with malpractice, we used care, but we did it negligently or incompetently. So negligence is the failure of care. Malpractice is that we used care, but we did not use it correctly. It's really the difference between the two. Okay? All right, good job, and thank you for that question.
So now let us turn our attention to legal documents versus medical care. This is very important. Legal documents must always be followed, even if the client is of sound mind and wishes for their own care. All right? In other words, the client may have given someone else a living will. This tells that person to make sure that they carry out their wishes, right? No tube feeding, no respiratory care. Even if they changed their mind, they gave their living will directives, also called a directive, to physicians or advance directives to the person in the legal world. So, a living will, also called a directive to physicians or advance directive, is a document that lets people state their wishes for end-of-life care in case they become unable to communicate their decisions. It has no power after death. Now, we must follow this living will. Oftentimes, siblings come in the institution or the hospital and say, Mom wanted this, 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 and this. And then the brother might say, no, Mom said she wanted dialysis. She told me that right before she died. Okay, that might be true. But the problem is, Mom did not change her living will before she got end of life sickness, right? So now she cannot change her living will. It's just like this. It's just like if you have a regular will, an estate will, and the parents decide to leave both of the children the estate equally, but then down the line they decide to change it and only give it to one person. Well, if they didn't change their will, their estate will, before they died, the court has to follow the original estate will, which means that both of the children will divide up the estate equally. Same thing with a living will. If one child wants something and it's written down, like Mom gave it to Susie, but she told the brother, she told her son, no, I want everything to happen. I want them to do everything they can to keep me alive. We have to follow that living will. Okay? Does that make sense? Great. Thank you guys for asking.
I also want you, ladies and gentlemen, to recognize that there's all kinds of different documents for healthcare. There's durable power of attorney, there's healthcare power of attorney, but for the purpose of the NCLEX, we're just going to talk about the living will, which we just did, and now we're going to talk about power of attorney. Power of attorney differs from a living will in that with a living will, an individual only has control over the client's health matters. A power of attorney document is a document that allows your client to appoint a person or an organization to handle their affairs while they are unavailable or unable to do so. It is important to know that a living will is not power of attorney. All right? One one document, power of attorney, allows an organization to take care of everything: the person's estate, their funeral cost, whatever it might be, whatever's in that power of attorney, right? The living will only has control over the health matters, and a lot of times people will give a power of attorney to a church or a funeral home or somebody outside the family so that there's no fighting, right? But a living will is almost always given to a family member if they have one, because that has control only over their healthcare matters. Okay, so in closing, it appears that we did go over terminology, the 5 different kinds of institutions, the rights of the individuals. But there's one thing I want to add real quick because I think that the NCLEX should talk about emergency versus non-emergencies in the instance of a minor or if the parent is a legal guardian, okay? Now, if it is an emergency, let's say you're taking care of your niece and you found your niece unconscious. That would be an emergency. You could take her to the hospital and we could take care of her, okay? But let's say your niece fell down the stairs and sprained her ankle and you took her to the emergency room. We would put ice on it, we would make her comfortable, but we would have to wait and get in contact with the parent or the legal guardian of that minor. And what I mean by a minor is anyone under the age of 18. Okay? That's just one more thing I wanted to add. And we're done with this presentation.